Definition of jurisprudence. Jurisprudence is the study or philosophy of law. It involves understanding the nature, purpose, and application of laws in society. Jurisprudence explores how laws are made, interpreted, and enforced, as well as their moral and social implications. Etymology. The word jurisprudence is derived from the Latin terms juris, law, and prudentia, knowledge, meaning knowledge of the law. Definitions by jurists. John Austin. Jurisprudence is the philosophy of positive law, focusing on the commands of the sovereign and the enforcement of those laws. Salmond. Jurisprudence is the science of the law, concerned with understanding the nature of law and its function in society. Scope of jurisprudence. Jurisprudence explores 1. Nature of law, understanding what law is and how it functions. 2. Purpose of law, exploring how laws maintain order, justice, and fairness. 3. Relation between law and morality, investigating the ethical foundations of legal systems. 4. Types of laws, analyzing the classifications of law, e.g., criminal, civil, international. 5. Social impact of law, studying how law interacts with society and adapts to cultural changes. Kinds of jurisprudence. 1. Analytical jurisprudence. Analytical jurisprudence focuses on understanding the law by analyzing its structure, language, and logic. It examines law as it is, without considering whether it is morally good or just. This approach often aligns with legal positivism. Key thinkers. John Austin, known for his command theory. Hart, differentiated primary rules, laws, and secondary rules, rules about how laws are made and interpreted. 2. Historical jurisprudence. Historical jurisprudence studies the development of legal systems over time, emphasizing the role of customs and traditions in shaping law. It focuses on how laws evolve in response to changing societies and cultures, and how legal principles are influenced by historical events and social practices. Key thinkers. Henry Maine proposed that law evolved from a system based on social status to one based on individual contracts. 3. Ethical jurisprudence. Ethical jurisprudence explores the relationship between law and morality. It argues that law should align with moral principles and promote justice and fairness. This approach evaluates whether laws are just and how lawmakers should act ethically in creating and enforcing laws. Key thinkers. Immanuel Kant believed laws must align with universal moral principles. 4. Sociological jurisprudence. Sociological jurisprudence views law as a tool for social change. It emphasizes that laws should adapt to societal needs and reflect the changing conditions of society. This approach focuses on how laws influence social behavior and strives to balance individual rights with societal needs. Key thinkers. Roscoe Pound advocated for social engineering, where law is used to balance individual freedoms with the collective good. 5. Comparative jurisprudence. Comparative jurisprudence involves comparing different legal systems to understand their similarities and differences. This approach seeks to improve legal systems by learning from others, promoting legal harmonization, and fostering a global legal framework that can address international issues like human rights and trade. Key thinkers. Scholars in this field compare legal systems globally, but do not have one central thinker. 6. Natural law jurisprudence. Natural law jurisprudence holds that laws should be based on universal moral principles inherent in human nature. It asserts that certain fundamental rights, such as the right to life and liberty, are inalienable and cannot be overridden by human-made laws. Key thinkers. Aristotle believed laws should align with natural reason. John Locke argued that laws must respect natural rights. 7. Realist jurisprudence. Realist jurisprudence emphasizes how laws are applied in practice, rather than their theoretical structure. It argues that law is influenced by social, political, and psychological factors, and that judges' decisions are shaped by real-world circumstances. Key thinkers. Oliver Wendell Holmes Jr. argued that law is shaped by experience rather than pure logic.